Before we begin, I just want to kind of share a piece of legal advice with you, so you don't make the same idiotic mistakes that I made. When very shortly after the book came out, it's been out, I don't know, maybe 8 or 9 years at this point, I started getting a lot of referrals from attorneys in my county in particular who had ethics issues. These are guys that I'd known for a long time. A lot of them were my friends. And I made the mistake of accepting their cases and undertaking to represent them, but not charging them a legal fee because I felt sorry for them and they were my friends and things like that. It's the biggest mistake you can make. One of the things you should get out of this class tonight is if you undertake to represent somebody in one of these cases, please charge them a legal fee. Your failure to do that will be, I don't want to use the word catastrophic, but extremely negative. Obviously, if you don't charge a legal fee, you're really not being fair to your other clients who have paid you already for your time. You're not being fair to your partner, certainly. But beyond that, doing these types of cases involve having your client make very difficult decisions. They involve a lot of stress, an enormous amount of work, and will call upon your best talents as an advocate. So apart from being deserving to be paid for your efforts, you've got to maintain a pure attorney-client relationship with your client, because if you don't, you're not going to be able to persuade him to do the things that have to be done in the case, sometimes which are very, very difficult for your client to do. And the other thing I've also found is in those cases where I did charge a fee after the case was over and I got a kind of a satisfactory result, we could go back to being friends again. Sometimes that doesn't happen if there's a money issue between you. So one of the things you should take away from tonight is when you do one of these cases, get an adequate legal fee because it's a lot of work involved in them. All right, now there is a market for this type of activity. This is a 5-year statistical breakdown of the number of orders of discipline that were promulgated by our Supreme Court over the preceding 5 years. The 2009 figures are out and they're consistent with this, so I didn't bother adding because it doesn't really bring anything to the table. Just concentrating on 2008 for a moment, 187 orders of discipline given out by our Supreme Court, and that's broken down as follows. There were 167 orders where final discipline was imposed, and by that I mean disbarments, censures, suspensions, just the normal gamut of discipline that's done on a final basis by our Supreme Court. An additional 20 orders of discipline related to temporary suspensions of attorneys. This will typically happen when the Office of Attorney Ethics goes to the Supreme Court and asks for a temporary suspension because the attorney has gone crazy or is not participating in a demand audit, or the attorney's been arrested or convicted for some very serious high-profile crime. Sometimes there's evidence that he's just not medically fit to be practicing law anymore. So there's kind of a wide variety of reasons, but there were 20 applications to that effect granted by the Supreme Court during the year 2008. Now you can see that the numbers do not vary all that much year in, year out. It's very, very stable. You don't have any big spikes where like one year you have like 500 people disciplined and then the next year it's only 100. Very, very stable year in, year out. Now in this business about new investigations docketed requires a little bit of explanation. The way the system works is that the local district ethics committees field what are referred to in the jargon of this as inquiries from members of the public, so that whenever a disaffected client goes to the district ethics committee with some type of complaint about a lawyer's conduct, the secretary of the committee has the responsibility for accepting the complaint. They accept all complaints. Kind of like municipal court, they accept all complaints for filing. It's like when you buy a car, no credit application will be refused. Doesn't mean you're going to walk away with a car, but they'll take your application. Same principle with the district ethics committees. They accept all complaints from the public, and they go through a screening process and kind of vet them out. Many times what will happen is the complaints have no merit to them because they're not alleging any violation of the RPCs. Sometimes the people are just crazy. Has anybody here ever had a crazy client, by the way? No? Oh, it's a very unusual crowd. But sometimes the people are just wacky. Often the complaint deals with a money fight between the client and the attorney, and it really has to be referred over to the fee arbitration committee because it's not an attorney ethics matter, okay? There's no violation there, okay? So quite a number of them are really vetted out of the system early on. But at the end of the day, and by the way, just around the state, the total number coming into the system in every given year averages about 6,000, okay? So about 6,000 inquiries coming in generally year in, year out. That's a pretty stable number. Once you kind of weed out the cases that have no merit, typically it'll be left over anywhere from let's say on any given year, maybe 1,500 that do have merit. In other words, there's probable cause based on the evidence to believe that the attorney has committed a violation of one of the rules of professional conduct, one of the RPCs. Now, once that occurs, the status of the case changes from what's known as an inquiry to a grievance. Grievances are basically, the process is that they will take the inquiry and they docket it. And once an inquiry becomes docketed, it's referred to as a grievance. Okay, so that's the technical jargon. You should understand that during the initial phase, when there's just an inquiry made, everything is confidential. You should also understand that during the entire grievance stage, the rules of court require that the matter be kept confidential, because you certainly don't want to have an attorney's reputation sullied in any way when you're really still investigating something and there's no clear proof that the attorney has violated any of the RPCs or done anything wrong for that matter. Okay. Now you can see that during the year 2008, there were 1,394 cases that went to grievance. All right, those are, in other words, of the 6,000 and some inquiries that got filed during that year by members of the public, it whittled down to 1,394. And the previous year, again, based on about 6,000, 1,553 went to the grievance stage. Now you should know, and we'll talk about this, that the grievance window, basically, in other words, in this process from beginning to end, the period of time when something is in grievance is an enormously important period of time. And very often, when you get involved in the case during that window, you're going to be able to do a lot of good stuff for your client and often get the case either diverted out of the system or get it dropped completely. Many of them are dropped at that stage due to effective advocacy. The problem you run into is sometimes your client doesn't come to you during that time period, and it's much farther down the line that you get involved in the case where your opportunity to do good work on the case is kind of gone because your client delayed in hiring you as an attorney. Now, cases that go through the grievance stage, again, many of them get worked out and just dismissed outright. But if there is evidence to suggest that the attorney has violated one of the RPCs at the end of the grievance investigation, the case really has two possible tracks it can take. It can be diverted out of the system, and I'll explain to you how that happens, or it will go to being a complaint. Now, once the matter becomes subject to a formal complaint, then the entire calculus changes. The whole system becomes public now. In fact, the matter would have to be publicly vindicated. Every aspect will be public. Public in the sense that if there's a hearing on it, the public has a right to attend, as does the press. Public in the sense that it can be in the newspapers, on television, on the internet. There's just really no restriction on it. And in fact, just last week, the Supreme Court promulgated some new rules dealing with television coverage of hearings related to matters that go to the complaint stage. But everything from that point on will have to be done in a public forum. All right. So just to compare the 2 years, 1,394 matters go to a grievance, and that resulted ultimately in 189 complaints being filed during that time period. So you can see there's, again, an enormous vetting process that goes on.